Paternity cases are different than divorce cases. A paternity case is basically the term we use when parents have children and they were not married. Sometimes people use the term never married. You don't have to have a controversy about paternity to have a paternity case. Even if you both agree that dad is the father of the child, you still have to file a paternity case instead of a divorce or instead of a custody case. A paternity case is started when either the mother or the father or the state of Arizona files paperwork to establish paternity. Oftentimes, a parent will involve the state by contacting the Arizona Attorney General's office and asking for their assistance to establish paternity and child support. Anytime that a parent seeks financial aid from the state, if they have not established paternity, the state will require that they go ahead and establish paternity because the state has a vested interest in getting paternity established and getting a child support order. In fact, in some cases, if a mother or a father is receiving cash assistance or other assistance from the state, they have to assign their right to collect child support to the state. So the state may be paying them a certain amount of money of cash assistance every month, and then the state will require the parent to cooperate with the state to go after the mother or the father for child support. And then when they collect that child support, sometimes part of that child support will go to the state, sometimes part of it will go to the parent. If the state is not involved, then either parent can file a private paternity action. In my practice, I would say well over 50% of the cases that have children at issue and parenting time and child support in dispute, they're not married, and so they come see me. Oftentimes the child is several years old or even 10 years old, and they've been working informally forever, and now one of the parents wants to get things formalized. So we start that process by filing a petition for paternity. Much like a divorce, you have to serve that petition for paternity on the other party. You can have that party sign something that's called an acceptance of service, which is basically a legal document that says, I don't have to be served, I got the papers, I understand I have 20 days to answer. Once a paternity petition is filed, the other party has 20 days to answer. However, there is a 10-day grace period because the party that started the whole process has to file something called an application for default. They just have to mail that to the other party. It's basically a 10-day warning that says you better file a response within 10 days or we could file a default against you. Once the paternity petition has been served on the other party has to file an answer. And they file that answer with the court. They have to mail it to the other party. And once the petition and the response have been filed, a process goes on that usually culminates, if the parties don't agree, in a trial. And that trial could occur anywhere between 6 months and 18 months after the original petition is filed. If either party cannot agree on money issues or on parenting time or on legal decision making for that 6 to 8 month period, either party can seek temporary orders. Those temporary orders are usually short hearings that occur in 4 to 8 weeks, and the court will issue temporary orders based on a quick hearing with usually just hearing from the parties and maybe a little bit more evidence. And the court will issue temporary orders about where the child will be living, how much time the child will be spending with each parent, and what type of financial support will be paid from one parent to the other. They will also address medical insurance at that time. Many people don't need these temporary orders because they have reached some kind of an informal agreement. If there is that kind of an informal agreement, it's always wise to get that agreement in writing. That can be by an email between the parties or by a text, but it's always good to have written documentation if you're relying on an agreement between the parties. If you have minor children involved in the case, then both parents have to attend mandatory parent education. Mandatory parent education is a half-day class. It usually occurs on a Saturday, and you have to attend that class within 40 days of the petition being filed. It's not a class so much about how to parent. It's really a class about how to get along with each other when the parents are not living together. It talks about communication. It talks about trying not to fight in front of the kids. It talks about not using the kids as go-betweens. Most of my clients find that this parent education class is very helpful, and the court requires you to go to that parent education class before you go to mediation and before you have any kind of a final hearing in the matter. After the answer to the paternity petition has been filed, the next stage of the case I call the disclosure and discovery stage. Both parents are required by law to disclose information to the other party. They're supposed to disclose all of the relevant financial information, such as financial affidavits, check stubs, profit and loss statements if they have their own business, tax returns, information from your company about the cost of medical insurance, and this process usually takes a few months. After the disclosure and the discovery process, oftentimes there's negotiations and offers of settlement back and forth, and the case settles. But if your case doesn't settle at this stage, then the next stage is to go to trial. And trials are set when one of the parties files a motion to set with the court. When that motion to set with the court is filed, usually within a month or so, the court issues a trial minute entry that gives you some very important and serious dates. They give you the dates for pretrial conferences, they give you the dates for disclosing all of your financial information, and they set the matter for a settlement conference, and they often set the matter for a final trial. It is very important that these dates are complied with. When you get that notice that gives you your trial date and your pretrial statement date, one of the most important documents that you have to file with the court before you have your final trial is called a pretrial statement. In that pretrial statement, you are supposed to explain to the court the pertinent information that the judge will need to know before he or she hears your trial. You have to list your witnesses, a way to contact those witnesses, and a brief description of what you think those witnesses are going to say. You have to list your exhibits, and you have to list why you think those exhibits are important. And you also have to list what it is you want. You have to list the type of parenting plan that you want, how much time you think the children will spend with you, how much time they will spend with the other parent. You have to list your position on decision making. Do you want both parents to have equal says over important decisions related to the children, or do you want one parent to make those decisions? Sometimes you can propose that there be a tie-breaking vote so that if you both can't agree, then you will allow your pastor to decide or your primary care doctor to decide. Prior to your final trial, there are a couple of serious opportunities to try to resolve your case. In Arizona, we have mandatory mediation regarding issues related to the child. Not financial issues, but issues related to parenting time and also issues related to legal decision making. Mandatory mediation occurs at the Pima County Conciliation Court with the parties and without the lawyers. Whatever the parties say in mediation is confidential, and if the parties have lawyers, even if they reach an agreement, it is not binding on the parties until 30 days after they've reached that agreement. This allows the parties to have an opportunity to go over it with their lawyers, and their lawyers may suggest certain changes be made to the mediation agreement. I encourage my clients to mediate openly and freely. I tell them, even if the agreement's not exactly what you want, but it's pretty close to what you want, go ahead and agree to it, let them type it up, and then we can talk about it and decide whether we want to suggest changes. We are not bound by the agreement until that 30 days pass. Another opportunity for settlement prior to your final paternity trial is a mandatory settlement conference. This is a program we have in Pima County that is an excellent program. Many lawyers like myself volunteer to be judges for these settlement conferences. They have certain powers of a judge, and they meet for an hour at court prior to the trial, and they try very hard to get both parties and their attorneys to reach agreements on some of the issues and hopefully all of the issues. Again, whatever occurs at that settlement conference is confidential unless the parties do reach an agreement. However, if they do reach an agreement, the judge, the volunteer lawyer who is a judge for that day, he will swear the parties in, he will have a tape recorder, and he will record that agreement, and he will make both parties swear under oath that they have reached this agreement and they understand that it's binding and that they cannot go back on that agreement. If there has been no agreement, then you have your final paternity trial. By then, you have probably already agreed as to the paternity of the parent. If there was no agreement, then the court would have ordered that there be a DNA test done, so the court and both parties will be absolutely certain that dad is the father. At that final trial, the court will determine some basic issues. One important issue that the court determines is past care and support. The judge has the right under Arizona law, in fact, the judge has the obligation to consider going back 3 years and ordering child support for the last 3 years. So for example, if the child has been living primarily with mother and father has not been involved or has been visiting the child somewhat but not paying child support or paying less than the guideline child support, then the court can order that he owes mother 3 years worth of child support. This is very, very important because a lot of times dads will be sending money or mom will be sending money to dad. They don't keep good receipts, and then the court will order 3 years worth of child support, and that can be in the tens of thousands of dollars. So it's very important if you have been working informally in a paternity case that you keep track of the financial support that you have been paying for the child. And it's also important that you know that you might owe 3 years worth of past child support, which could be tens of thousands of dollars. And usually the court will order that that be paid in a certain amount per month. The other important things that the court has to decide are parenting time and decision-making and future child support. Parenting time and decision-making in Arizona used to be called custody. They used to have joint legal custody or sole legal custody. Now they have shared decision-making or sole decision-making. They used to use the term joint physical custody or primary physical custody. Now the terms are equal parenting time or primary parenting time or primary residence. And there will be other videos that give you more details about these terms. Lastly, the court will have to make an order about future child support. And Arizona has very specific guidelines that have to be followed in most cases that require the court to consider the income of each parent, the cost of the medical insurance for the children, the cost of daycare that is related to work, and the amount of time the child spends with each parent. And when the court has all of that information, they basically plug it into a form, and that form spits out a very specific number. Once the trial is over, the judge usually takes the matter under advisement and issues a written ruling within 60 days. Most judges issue those rulings prior to the 60 days, but when you get that ruling, that is going to be your final paternity order, your final order about past care, about child support, about parenting time and decision making. And then hopefully you will live happily ever after that.